Hi guys, welcome to my channel, The Legal Affair, with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on reckless credit agreements. Please, of course, do remember to subscribe to our channel on YouTube, The Legal Affair. You can also follow us on social media, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. That's at attorney_bay. So when it comes to credit agreements in South Africa, we know that the law or the legislation that deals with or regulates credit agreements is the National Credit Act. Now, the National Credit Act deals quite extensively with credit agreements. It also deals with obligations that credit providers, such as banks, have. And of course, the National Credit Act also tries to protect the rights of consumers by placing various obligations on credit providers. We do also know that in South Africa, we have a national credit regulator, which is the entity or the body that is responsible for the regulation of credit by credit providers. Of course, when it comes to the National Credit Act, there are instances where the National Credit Act is applicable or the National Credit Act isn't applicable. So there's a differentiation between credit agreement where the National Credit Act applies and credit agreement where the National Credit Act doesn't apply. Of course, the obligations for credit providers where the National Credit Act is applicable differ from the obligations of credit providers where the National Credit Act isn't applicable. So how do you actually find out if your credit agreement has a National Credit Act applicable or not? The credit agreement must always state on the credit agreement, is the National Credit Act applicable or is the National Credit Act not applicable, rather. So as mentioned, the National Credit Act deals quite extensively with credit and specifically reckless credit and various other principles when it comes to providing credit to consumers. Now, we do also know that debt counseling is referred to or regulated also in the National Credit Act. We know that the services of a debt counselor often come at a fee. Of course, the National Credit Regulator also has a list of companies that are classified or registered with the National Credit Regulator. So, should you, as a consumer, find yourself over indebted or unable to pay your debts, you do have the option, of course, of referring or using the services of a debt counselor. It's important, of course, to note that a debt counselor may charge for their fees. You must always also try and check the website of the National Credit Regulator to see whether that particular debt counselor is approved. Now, the services that debt counselors provide are quite extensive, and some of these services, for instance, include revising the payment terms for a particular consumer, reducing the payment terms for a particular consumer. Managing the consumer's credit agreements and their obligations as provided for in the credit agreements. In some instances, the debt counselor can actually amend or request a credit provider to change some of the terms of your credit agreements. And of course, a very important role that debt counselors play is assisting consumers to have an agreement referred to as a reckless credit agreement. Now, with reckless credit agreements, these are agreements that are provided to consumers that actually shouldn't have been given to consumers. So when a credit provider gives credit to a consumer that it shouldn't have, in other words, when a bank gives a home loan or a personal loan or a loan relating to vehicle financing they shouldn't have, there is a possibility, of course, provided that certain requirements are met, that that particular loan can be classified as a reckless credit agreement. This is because the National Credit Act places quite a number of obligations on credit providers to ensure that they check the payment history of a particular consumer, the ability of a particular consumer to afford the credit that is being offered to a consumer. So in a nutshell, the National Credit Act places various obligations on credit providers to ensure or to check whether or not a consumer actually can afford the credit that is being offered. In an instance where a credit provider, of course, gives credit to a consumer who can't afford that credit, that agreement can be regarded or classified as a reckless credit agreement. And for the consumer, the benefit or the gain is that that consumer will no longer owe or have any obligations in relation to that agreement. So in essence, that agreement will fall away. Now, some of the obligations that a credit provider, for instance, a bank, has before they provide credit to a consumer is that, number one, banks and various other credit providers have an obligation to check the payment history of a particular consumer. So they actually need to see how you have previously paid off some of the credit that you used to have. Credit providers also have an obligation to, that is prior to granting a consumer credit, to check your existing financial means. So not only checking your previous payment history, but to check your existing financial means. So currently, at the time you do or have the application for credit, are you able to pay? Are you able to pay in accordance with the terms of the proposed credit agreement? Now, when it comes to credit agreements and specifically reckless credit agreements, there are various classifications or categories for reckless credit agreements. There's actually three. Now, if it so happens that your credit agreement falls within one of the classifications, it is actually possible to have that credit agreement declared a reckless credit agreement. And of course, what that entails is that that agreement will fall away, meaning if a credit agreement rather is classified or regarded as a reckless credit agreement, that agreement lapses. So it's no longer a contract, and you as a consumer no longer have any obligations according to that agreement. So if you took out a personal loan or a home loan or any other loan, really, or any other form of credit also, and that credit agreement is regarded or classified as a reckless credit agreement, you will no longer owe the credit provider. Now, like as mentioned, there are three classifications or categories of reckless credit agreements. Number one, a reckless credit agreement could be a credit agreement where a credit provider, for example a bank, provides credit to a consumer without conducting any background searches on that particular consumer. So as I've mentioned, when a credit provider like a bank gives credit to a consumer, so in other words they give you a home loan or a personal loan, a bank actually has an obligation to check your ability to pay that particular credit, in accordance with the payment terms, your history when it comes to paying credit agreements, and of course your existing obligations, financial obligations. So what do you currently owe, and should you take out that credit agreement, will you be able to pay it back? So number two, or the second classification when it comes to reckless credit agreements, if a credit provider gives credit to a consumer, and they have done an assessment on that particular consumer. However, from the merits of the matter or having considered the matter, it is obvious that that consumer that they had given credit to doesn't understand the obligations or the risks rather, that are affiliated or associated with that credit agreement. So put very simply, if a bank gives a loan, a personal loan or a home loan to a consumer, and that particular consumer doesn't understand what it actually means to take out a home loan, or they don't understand the risks that are affiliated with a home loan, that credit agreement, where the bank has given a personal loan or home loan, can be regarded or classified as a reckless credit agreement. So what's important when it comes to credit agreements is that the institution that gives credit must ensure that the person that they are giving credit to actually understand what credit entails. So obviously if you take out a credit agreement, you're going to be taking out for instance, if you take out a credit agreement rather with a bank, it's likely that there will be interest on that particular loan. For instance, if it's a loan that you've taken out, you have an obligation to ensure that you keep up with payments on a month-to-month basis. And of course, in many instances, if you aren't paying your credit agreement, you are likely to be found in breach of your credit agreement. And of course, in some instances, if you can't afford to continue to pay the credit as set out in your credit agreement, usually as a consumer, you have an obligation to inform your credit provider like a bank. So if you take out a home loan, the bank needs to tell you, for instance, that you have a certain amount that you are going to be paying on a month-to-month basis, that there is interest on that particular amount, and that you have an obligation to ensure that you are always paying. And of course, in an instance where as a consumer you find yourself unable to pay those debts back, it is likely that you have an obligation to ensure that you advise the credit provider that you are unable or can no longer afford to keep up with payment terms as provided for in your credit agreements. The third classification or category of what constitutes a reckless credit agreement is in an instance where a credit provider does do a search on a consumer rather, and it turns out that after doing that search, the credit provider can see that that particular consumer is over indebted, but nonetheless provides credits to the consumer. So in very simple terms, if for instance you take out a home loan or a personal loan and the bank does do an assessment on you, but they realize that you are over indebted, meaning on the basis of your month-to-month expenses, you actually can't afford to pay the credit agreement in accordance with the terms of that particular credit agreement, but the bank nonetheless offers you credit. That could be classified as reckless credit on on the side of the credit provider, for instance, a bank, and of course, the benefit for the consumer is in an instance rather where a credit provider opts to provide credit to a particular consumer where the consumer actually is over indebted. That credit agreement could be classified or declared a reckless credit agreement. So there are of course three categories when it comes to credit agreements, and being classified a reckless credit agreement specifically. There are three rather categories. The National Credit Regulator can also be of assistance or give guidance when it comes to credit agreements. Should you find yourself in an instance where one of those three scenarios that I've mentioned are applicable, you can of course refer that particular credit agreement to the National Credit Regulator. You can check the National Credit Regulator. My tongue. You can check the National Credit Regulator's website on how to refer a dispute to them. But for specifically consumers that have found themselves over indebted or unable to pay their debts, it is quite important to actually try and see whether or not that particular credit agreement can be classified as a reckless credit agreement. And in an instance, as mentioned, if a credit agreement is classified as a reckless credit agreement, you as the consumer, for instance, if you took out a loan such as a personal loan or home loan, no longer have obligations in terms of the credit agreement. So however much money you loaned, you need not pay back. But of course, that credit agreement must be classified as a reckless credit agreement.